Well, when Peter asked me to speak, he said Q&A. And I took that as a very literal Q&A. And I asked him, do you need to prepare any presentation at all? He said, no, we'll just do Q&A. And then I see this flyer this morning, and I should have opened it a little sooner, and he said, well, she's going to cover these topics. I'm like, okay. But luckily, I only practice in the area of family law, so it's not like I had to research the topics or anything like that. My name is Erica Christian, and I work with Cordell & Cordell. We opened our Milwaukee office approximately 2 years ago, and opened the Madison office in January. And I'm the litigation manager, so I take the cases here, and I also manage the cases in the Milwaukee, Waukesha area. The initial consultations, I do all of our initial consultations, and I guess I was going to kind of start off that way to talk about the information that I gather from someone and then lead into the divorce process. So when a client is first coming in, the information that I'm gathering is, all right, how long have they been married? How many children do they have? Where are the children living? What their incomes are, if the other person is employed or not employed, if either party is unemployed, how long have they been unemployed? Why are they unemployed? And I take that information, the first issue that we always confront is the issue of children. I want to know status quo. What have you been doing regarding the relationship you've had with your children? Because a lot of people, they come in and they left the house. They left the house because she kicked him out. Meanwhile, she's not letting him back in the house, and he doesn't get to see his children. So then I have to find out, well, what were you doing before? And then we come up with, we talk about, what his relationship was with his children, what he wants his relationship to be with his children. And the key is I ask, what do you think is best for your children? It's different from what I want. If I asked any of you what you want your schedule to be with your children, most of you probably would say 100%. 100% with me. That's what I would want. And so the next question is, well, what's best with your children? Recognizing that your children need both of their parents, depending on the circumstances, and then going from there. So we talk about custody and placement and how they are two very different concepts. Custody being decision making. A lot of people say, when they come right in, they say, I want 50-50 custody. They say, you mean 50-50 placement. Custody referring to, obviously, decision making, where the children go to school, what elective medical procedures they have, what religion they are. It's either sole custody or joint legal custody. In Wisconsin, there's a presumption of joint legal custody unless there's a reason, and there's statutory factors. Really, generally, there's a reason, and that's why we shift to sole legal custody. Or if it's a situation, depending on the judge, where it's clear that the parties cannot come to an agreement at all whatsoever on any issue, and then the judge basically says, okay, I'll pick. Custody, and then there's placement. Placement is the time that your children spend with each parent. Wisconsin, we tend to look at overnights, because overnights translates to support, depending on the judge, completely depending on your jurisdiction. Some courts are recognizing full time and looking at the actual time that your children are awake, but it entirely depends on your judge. But basically, the schedule. Maybe a different schedule for summer versus the school year. You may have a flexible schedule, and then we set parameters regarding the schedule. But ultimately, you tell me what's best for your kids. And the key is you telling me what's best for your kids, and we go from there. Because you bring the court involved. You bring the court in, you bring the guardian ad litem in, you bring the social worker in. Some of you have gone through the social worker process, or some of you had a guardian ad litem who met your kids once, maybe. You didn't get a letter of recommendation from their children saying how they did, but they're going to tell you how you're going to be parenting your children. So the key is figuring out what you want, what you think is best for your children, and then going from there and setting yourself up for success is the key too. That's a big thing that I talk about with my clients is let's talk about how we're going to get there and what we need to do, because I understand what your end goal is, but sometimes we delay filing, sometimes we take certain action just because we know how it's going to appear to the court. So after we talk about custody and placement, we go into support and we talk about the statutory guidelines for child support. We talk about different discounts that there are, for example, health insurance. We talk about uninsured medical expenses versus variable expenses. And and then we get into maintenance or alimony, and then we talk about property division and maintenance buyouts, hopefully, for those who are married for a very long period of time. But again, we talk about the factors when it comes to child support versus maintenance. And then we talk about the property division, the assets and debts that are there, and more common nowadays is how we're going to incorporate a bankruptcy into the division, considering both parties will be leaving with a substantial amount of debt. But that's general theme of what we go into in an initial consultation. I also go through the divorce process, and I do have, some of you look very familiar. And so some of you I know have been through this process, and you know it. You can probably come up here and do the presentation for me, but for those of you who might be just starting the process, I do have a flow chart that I go through with my clients on the divorce process in Wisconsin, and it's obviously tailored by county because some, for example, there's an order to show cause hearing, a temporary order hearing. Some counties it's elective, some it's mandatory. So we just go through county specific, but it would probably exhaust you for me to go through all of that. Now those are for guys who are coming in and they are just starting the process. Other types of cases that come in quite a bit are modifications. So you have a set schedule right now and you want to change the schedule. And we talk about the different burdens that there are. We talk about the 2-year truce period for placement. For those of you who aren't familiar, when you have a final order with respect to custody and placement, whether it be a paternity or divorce case, for 2 years there's a higher burden, and you have to show that under the current arrangement the children are at a substantial risk of harm. Once you show that their children are at a substantial risk of harm, then you have to show, you go to the next standard, which is what schedule would be in the children's best interest. Obviously it's very challenging under a 2-year truce period to change the schedule, but there are many situations where it's both appropriate and necessary. And then we talk about a situation where it's after the 2-year truce period, and then we're asking what substantial changes and circumstances have there been since the last, since the final order, and then we talk about what the schedule should be and what's in the best interest of the children. But I do have some information on modifications if that's where you're at as well.
Tim here had a question earlier, maybe you can clarify as long as you're on that subject, about the 2-year rule and when the clock starts, literally.
Yeah, does it start from your actual divorce, the day of when you're in court, or when the papers are signed? I could never get a clear answer, so I actually waited till the day the papers were signed to file for my modification. Because it took like 3 months.
So the issue with, it depends on the county. So for those of you, just to clarify, what he's talking about is when the clock starts for the 2-year truce period. There's a lot of litigation going on with that right now for a number of reasons. In paternity cases, for example, the parties in Dane County, just to give you an example, so the parties, they don't have an agreement, so they send it to mediation. And you go to mediation, and maybe you came to an agreement, and they send that agreement to the court. And you get a notice that says, if you don't dispute this mediated agreement, within 30 days it'll become a final order. But under the statute, it's technically, and then you get an order, by the way, from the court, and it references the old statute and doesn't reference the new statute. So it's not clear when the clock starts ticking. So there's lots of issues right now on when the clock starts ticking. It's supposed to be from the date that the order was entered. And that would be the day you were actually in court, the day you testified that you thought that placement schedule was in your children's best interest. Unless we're talking about a situation where you never testified regarding the placement schedule and then the order just went to the court. Was it a divorce?
Yes.
Okay, so you were in court.
Yes.
Yeah, that would be your day.
That's what I thought, but I couldn't get a clear answer on that from anyone at the courthouse.
And a lot of times the court won't enter a judgment in court that day, right? I mean, that's probably pretty common, but they'll hear testimony, arguments, all that. Then you have to wait till they...
Well, did you have a marital settlement agreement?
Yes.
Okay, so after a final divorce hearing, the court generally had attorneys,
I didn't know.
but she had an attorney?